Welcome to the Supreme Court of the United Kingdom, where we are today on the first day of a two-day hearing in the appeal of Pakistan International Airline and Times Travel, a case concerned with the concept of duress in the law of contract. We're currently hearing submissions on behalf of the appellant, the airline, presented by their counsel, Philip Shepherd, Queen's Counsel. So I'll now turn to Mr. Shepherd and invite him to continue his submission.
I'm counsel for Times Travel, the appellant.
I do beg your pardon, Mr. Shepherd. So I don't quite know how I made that mistake.
Lord, can I just go back to the question that Lord Burrows asked me before the short adjournment? And that was whether I was going to refer to other cases on lawful act duress. And in fact, I found that the very best summary, given the time constraints today, is to be found in Lord Burrows' restatements, which in the electronic bundle is at page 6981. Now, I apologize in advance that the copy at 6981 is very poor indeed, because it's so small as to be virtually unreadable. But if you'll bear with me at 6981 and go to 6983. If my lords have that, at 11.3b, Professor Burrows, as he then was, says this: the very language chosen by the courts of the threat needing to be illegitimate rather than unlawful suggests that there may be lawful act duress. This is borne out by the case law. A long-established area, although traditionally thought of as within the equitable doctrine of undue influence rather than the common law doctrine of duress, an historical difference that in this area we can cut through so as to unite all examples of illegitimate threats, and he refers to other paragraphs of the commentary, comprised illegitimate threats by, for example, threatening to prosecute or expose the truth about the claimant or a relative of the claimant. And Professor Burrows refers to Williams and Bailey, and then to Mutual Finance and Wetton. It says, again, although rare, it has been accepted that economic duress can extend to threatened unlawful acts. And he refers to CTN, to Alf Vaughan and Roy Scott, to R versus the Attorney General, which we looked at just before the short adjournment, and to Progress Bulk Carriers. Alf Vaughan is at 3115. I don't ask you to go to it now. And all of the others are in the bundle. My lords, I would add to that list Borelli and Ting as another case of lawful act duress, but where the background was in unlawful conduct. Borelli and Ting you can find at 1329. It was concerned with an agreement entered into by the former chair of a Bermudian company in insolvent liquidation, where liquidators needed to put in place a time-limited scheme of arrangement to fund the liquidation that Mr. Ting, who had in the past procured the forgery of his signature on board resolution, was threatening to oppose. The facts really don't need any further elaboration, but all I would say about that case is that the threat that was used by Mr. Ting was that he would veto a scheme which the administrators were putting forward. This is founded on, by my learned friends, the respondent at paragraph 47 of his case, to argue that Borelli is a case of unlawful act duress on the basis of Mr. Ting's threat to veto the scheme, saying that this constituted a breach of his statutory duties under the winding up rules of Hong Kong and Bermuda. But actually, the relevant action is the exercise of a veto, which in paragraph 48 of the respondent's case, they refer to and accept is lawful. Therefore, such a threat cannot be the basis for saying that the threat to veto the scheme constituted unlawful means. There was no suggestion in the case itself that everything turned on whether the immediate threat was lawful or unlawful. So Borelli, we submit, is a case of lawful act duress. Now, in the time available, I just want to turn to a very few additional cases. The first is CTN, Cash and Carry and Gallagher, because it was much relied on by the Court of Appeal in this case. If you go to 1428, my lords, and my lords, what we say CTN is authority for is that although in certain circumstances a threat to perform a lawful act coupled with a demand for payment may amount to economic duress, it is difficult in a commercial context to maintain such a claim. But Lord Justice Steyn, as he then was, is careful to say, never say never. But my lord, that is a case which we submit is very fact sensitive. And I make these following points. It was a sale of goods case where the relationship was of seller and buyers under individual contracts, not a relationship of agent and principal as in the present case. Secondly, under one contract, goods were wrongly delivered and then stolen. Gallagher invoiced CTN for the stolen goods, even though the property had not passed to them and they were still at Gallagher's risk. But Gallagher honestly believed otherwise. And at 1431, Lord Justice Steyn points out this was not a protected relationship, but an arm's length relationship between commercial parties. And that even though Gallagher was a monopoly, that didn't elevate duress, non-duress into duress simply for that fact. And the particular facts that are relied on by the Lord Justice. At 1431J, he refers to this not being a protected relationship. He then goes on to say a second characteristic of the case is that the defendants were entitled to refuse any future contracts. And a third, which he refers to as crucially important, is that the defendants bona fide thought that the goods were at the risk of the plaintiffs. Now, if you go to 1432, you'll see that Lord Justice Steyn at letter F quotes a passage from Professor Burke's in his 1997 Introduction to the Law of Restitution, who answers his own question, can lawful pressures also count? He says this is Professor Burke says this is a difficult question because the answer is that they can. Any viable basis for discriminating between acceptable and unacceptable pressures is not positive law but social morality. In other words, the judges must say what pressures, though lawful outside the restitutionary context, are improper and contrary to prevailing standard. That makes the judges, not the law or the legislature, the arbiters of social evaluation. On the other hand, if the answer is that lawful pressures are always exempt, those who devise outrageous but technically lawful means of compulsion must always escape restitution until the legislature declares the abuse unlawful. It is tolerably clear that at least where they can be confident of a general consensus in favour of their evaluation, the courts are willing to apply a standard of impropriety rather than technical unlawfulness. At 1433, just one more passage, where Lord Steyne says that the aim of our commercial law ought to be to encourage fair dealing between parties, but it's a mistake for the law to set its sights too highly when the critical inquiry is not whether the conduct is lawful, but whether it is morally or socially unacceptable. That is the inquiry in which we are engaged. In my view, there are policy considerations that militate against ruling that the payment of the disputed invoice by duress. The policy matters that he goes on to refer to are matters such as the importance of certainty in commercial dealings. He goes on to say, outside the field of protected relationships in a purely commercial context, it might be a relatively rare case in which lawful action, duress can be established. And Lord, indeed, it might be a relatively rare case because the conduct of the kind in question in this case is, as far as we know, unprecedented, particularly by a flag carrier airline. Lord Steyne goes on to say it might be particularly difficult to establish duress if a defendant bona fide considered that his demand was valid. Lord Steyne was not, Lord Justice Steyne was not attempting, we submit, to lay down some additional requirement to duress in law. What he was simply doing was describing one of the matters that might be taken into account when considering whether duress had been established or no. He didn't seek to suggest that the defendant's bona fide belief was to be determined. He expresses it in a very cautious way, saying it might be particularly difficult. So it's a relatively tentative suggestion, but as we will contend, it focuses on the duressor and his beliefs, not on the duressee and the effect of the coercion. Lord Steyne goes on to say, in this complex and changing branch of the law, I deliberately refrain from saying never, but as the law stands, the defendant's conduct in this case did not amount to duress. It says it's an unattractive result, but my lords, the particular matters to bear in mind about CTN is that the facts are very particular to CTN. They're nothing like the present case. There was no existing breach of contract. The amount of money concerned was trivial was between these trading companies. Secondly, Gallagher was entitled not to contract in the future, and there was no suggestion that CTN was being put out of business, no ratcheting up of pressure. And thirdly is the fact that Gallagher honestly believed the goods were at the risk of CTN. But that is a matter of some technical difficulty. But to the extent that it is relevant, I submit that bona fides of the party applying the pressure is to focus interest on the wrong party. Contrast the facts of the instant case. Our submission is that however low the bar is set in the conduct of the respondent in a commercial context, is that it fell so far below that standard that involved an original breach of contract by the respondent in failing to pay over £1 million in accrued commission against a blameless agent who was threatened with being put out of business. The pressure being deliberately increased by destroying its cash flow by cutting ticket supplies by 80%. And all of that was directed at only one thing, which is forcing the appellant to give up accrued earnings gained by generating ticket sales for the respondent. So it was money that the respondent had already received on sales generated entirely by the appellant. So rather than dispute liability and seek to have the matter resolved independently, they resort to coercion. That, we submit, is a long way the other side of illegitimate by the most generous definition. Then a few brief remarks about the additional cases at appeal level. In Lord Debenture in the Court of Appeal, as counsel for Ukraine observe in their case, the parties were agreed on the applicable principle. There was no suggestion that only unlawful acts would qualify as illegitimate pressure. We can see that. I'll give you the reference 4847, paragraphs 157, 158, 159, and 160. So that was common ground at appeal level. My Lords, at first instance, there are a few but not many cases. My Lords have seen mention of DSND, Subsea and Petroleum Services. That was a case which adopted a multi-factor approach. Again, in light of the time, I'll give you the reference, but won't take you to it. It was a factually complex case where there were a web of contracts and variations. See paragraph 17 to 36 on pages 1461 to 1463. So a thoroughly commercial case. And your Lordships will have seen at paragraph 131, page 1471, that Mr. Justice Dyson, as he then was, refers to a range of factors, including the bad faith of the party applying pressure, but also matters such as whether the party had any reasonable alternative, which, as you know, was conceded in the case, in the instant case. My Lord, I note in passing, but I don't take you to, another commercial decision, David Donaldson QC in Adams and Mitras. It's at page 624 of the bundle. Once again, an absence of reference to good faith and no difficulty in the application of the doctrine in a completely commercial setting. In particular, see pages 628 and 629, in which one can see the complexities of the supply contract that was in issue in that case. I rely on those cases to show that the empirical evidence about uncertainty and vagueness just isn't there. And in this jurisdiction, one struggles to find any dicta of any kind, other than the Court of Appeal's judgment, that shows that judges at the sharp end of applying the doctrine are struggling to find the forensic tools with which to do the job. My Lord, can I turn to progress bulk carriers, because it is a decision of some importance, we submit. Mr. Justice Cook, a very experienced commercial judge, it's page 2015. My Lords, I've already referred to the facts. The owners had earlier broken a charter by failing to provide the chartered ship. They then strung the owners along, saying that they would make things right with a substitute vessel and a discount on freight, but then refused to provide a replacement vessel unless the charterers waived any claim for damages. Mr. Justice Cook held that the agreement to waive the claims was avoidable for economic duress. And if you would go to page 2017, paragraph 1, you'll see this is an appeal on a point of law from arbitrators, where the arbitrators, where the question was on the basis of the findings of fact in the award and reasons, was the settlement agreement made between the parties voidable for duress, and in particular, did the owner's conduct amount to illegitimate pressure? The illegitimate pressure required to establish duress in law. Then at paragraph 13, my Lord finds the finding of the majority was that the settlement agreement by which the charterers agreed to waive their claims for breach was capable of being set aside. I draw attention to paragraph 14, and paragraph 17. The law is set out at paragraph 21 on page 2021. And I just asked you to note paragraph 28, letters E to F show what I submit are the clear parallels with our own case. In paragraph 30, Mr. Justice Cook refers to what he refers to as the critical inquiry. In paragraph 32, I'll just take this up because it refers also to Mr. Justice Mance's decision in Creamer. He says that the judge referred to CTN, referring to a dictum of Lord Gough in the later decision. Lord Gough had said that it was accepted that economic pressure could amount to duress, provided that the economic pressure could be characterized as illegitimate and constituted a significant cause inducing the plaintiff to enter into the relevant contract. Mr. Justice Mance went on to state that this left room for flexibility in the characterization of the illegitimate pressure and the relevant causal links. He said that the recognition of some degree of flexibility was not open to the reproach that it introduced a judicial discretion, because courts frequently had to form judgments regarding inequitability and unconscionability, giving effect in doing so to the reasonable expectations of honest people. It was the law's function to discriminate between different factual situations, so it was appropriate to adopt the approach set out by Lord Justice Steyn in CTN by focusing on distinctive features of the particular case and deciding whether or not it did amount to a case of duress. And he then goes on to cite a number of other examples, some of which I haven't mentioned, including David Donaldson in Litras. In our submission, one can take the matter to paragraph 39. Paragraph 38, I'm sorry. The owners contended that the arbitrators had not found any threatened breach of contract by them in refusing to ship the cargo on the Agia, that was the alternative ship, without a waiver of rights by the charterers. It is true that the arbitrators made no finding that there had been a binding agreement made on the 27th to ship the cargo on the Agia, so that there could be no threatened breach in refusing to do so without the waiver of rights. What, however, the owner's submissions overlook is the fact that their repudiatory breach was the root cause of the problem, and that their continuing conduct thereafter, as described by the arbitrator, designed to put the charterers in a position where they had no option but to accept the settlement agreement in order to ship the cargo to China and avoid further huge losses on the sale contract to the Chinese receivers. As the charterers submitted, it would be very odd if pressure could be brought about by a threatened breach of contract which did amount to an unlawful act, but not by a past breach coupled with the conduct since the breach which drove the victim of the breach into a position where it had no realistic alternative but to waive its rights in respect of that breach in order to avoid further catastrophic losses. And he then goes on to refer to the factors referred to by Mr. Justice Dyson in DSND, and says that Dyson J expressly include those factors, especially including an actual breach as well as a threatened breach of contract. And here there's no doubt about the situation. While the arbitrators did not expressly find the owners were in bad faith in what they did thereafter, it's clear that the arbitrators took the view that the owners had manoeuvred the charterers into the position they were in, following the breach in order to drive a hard bargain. Charterers had no realistic practical alternative but to submit to the pressure. They did protest at the time, they didn't affirm the contract, and so forth. In my judgment, it cannot be said that the arbitrators applied the wrong test, and so forth. So, my lords, we submit that that case is authority for the proposition that where there has been a breach of contract, as there had been in this case, and there is a continuum of events which is designed to put the victim of the breach of contract into a position where they have no alternative but to accept a waiver of past breaches. Those are all relevant factors to be taken into account, and that it is wrong in principle simply to focus on the legality of the action designed to bring about the pressure in question. I'm going to say something about good faith in just a moment. But very nearly finally, as regards authority, if I can draw your attention to Alna, Yarn and Kent, which your lordships will find at page 641. My lord, Lord Burrows.
Sorry to interrupt, and it may be that you are going to deal with this point because I think you've just told us you're going to deal with good faith. But just before we leave the Progress Bulk Carriers case, paragraph 40, while the arbitrators did not expressly find that the owners were in bad faith, etc., in our case, might it be said against you that we have been in fact presented with facts where it is decided that there hasn't been bad faith because there was a genuine belief, as I understand it, is the finding, that the defendants thought that they were doing what they were entitled to do? Might that be a distinction between our case and the Progress Bulk Carriers case?
Well, Lord, only to this extent. I'll show you what was actually decided by Mr. Justice Warren. He found neither good faith or bad faith on the part of, he expressly says that. That's point one. And secondly, one of the claims was a claim that was so strong that nobody had articulated, least of all the respondents, what their defense to it was. And that was a claim known as the YQ claim, which was a claim for commission to be paid on that part of the ticket which comprised fuel surcharge, that part of the fare comprising fuel surcharge. And indeed, as things turned out, that claim was the subject of a successful summary judgment application. So there are those points of distinction. There are claims which the defendants, the respondents, to which they had no defence at all and could never have thought they had, not least because there was a Court of Appeal authority from Australia on exactly the point in question, the contract being a contract adopted throughout the world, and that very issue had been decided by the Court of Appeal in Australia. And there was no point of relevant distinction between this case and the Australian case. So even if the respondents had genuinely believed in their defence to the rest of the claim, and I'll show you a passage in due course, but it is distinguishable in material respects. But of course, my primary submission is that good faith is neither here nor there, and it certainly shouldn't be the determinative factor, particularly because Mr. Justice Warren made the finding that it was extraordinary in this case that the respondent had not called any of the persons who were directly responsible for making the decisions in question. And he remarked on that as being extraordinary. So it was seemingly a tactical ploy on the part of the respondents to keep away from court anyone whose good faith or bad faith could be relevant or could be the subject of examination at the trial. And that is just the sort of problem that is encountered by those at the coalface of the commercial court, of the sort of tactics that can be adopted if it becomes known that good faith and bad faith is an issue, and the party concerned simply deploys the tactic of not calling any of the relevant witnesses. Although we did manage to call one of them ourselves. My Lord, can I just very quickly go on to Al Nahyan, because I've got a fair bit to cover. Perhaps the best way of my dealing with it is to take you to page 698. Lord, this was a joint venture in which Lord Justice Leggett is dealing with the breakup of that joint venture. The joint venture being a venture to develop hotels in Greece. That doesn't matter for the purpose of this submission. If you go to page 698. You'll see that Lord Justice Leggett at paragraph 178 starts the discussion of duress, and he refers to the usual suspects when it comes to authority at 179, and he refers illuminatingly at paragraph 180, having just quoted the now well-known passage from Lord Atkin in Thorne. He says, for the purposes of the criminal offence of blackmail, the question whether a demand was justified involves a subjective test. Under section 21 of the Theft Act, a person commits the offence if, with a view to gain for himself or another, with intent to cause loss to another, he makes an unwarranted demand with menaces. For the purposes of a demand with menaces, it is unwarranted unless the person making it does so in the belief, A, that he has no reasonable grounds for making the demand, and B, that the use of the menaces is a proper means of reinforcing the demand. Then he says this, in civil as well as in criminal law, the state of mind of the defendant is naturally a relevant consideration, where the question is whether the defendant has acted wrongfully. But the factors which render a contract effective and making it just to require contractual benefits to be restored are not limited to cases where the defendant has acted wrongfully. They include, for example, a case where a party lacks capacity, or one party is under the undue influence of the other, even though such influence may not involve any wrong. They may also, in principle, include cases where the defendant has exploited a position of extreme vulnerability on the part of the claimant to induce the claimant to agree to a wholly unreasonable demand. There is no reason why, in this context, the availability of relief should depend on the defendant's own perception of whether his conduct was justified. Of course, I rely on that. On the contrary, as in other cases where the law sets limits to freedom of contract by requiring the parties to observe certain minimum standards of behaviour, the appropriate arbiter of those standards is the independent judgment of the court. In a number of cases, the courts have recognised that making a lawful threat to press an illegitimate demand may constitute duress, and that the measure of legitimacy for this purpose is not the defendant's self-assessment, but prevailing standards of morality and propriety. He cites CTN. He then says, Lord Justice Steyn thus declined to accept that the defendant's state of mind was conclusive, and also emphasised that the critical inquiry is not whether the conduct is lawful, but whether it's morally or socially acceptable. He says, in a judgment of the Supreme Court in Crescendo Management, which your lordships have, referred to by Lord Gough in the Evia Luck, Mr. Justice of Appeal McHugh at 46 said, pressure will be illegitimate if it consists of unlawful threats or amounts to unconscionable conduct. In Heighton and Creamer, Mr. Justice Mansley then cited these authorities and identified the rationale of the law's intervention to prevent unconscionability. And Borelli and Ting refers to unconscionable conduct yet again. Just across the page, my lords, there's perhaps just at the foot of that page of 700, it says, amongst other illustrations, a test of this nature may explain cases involving a threat of prosecution if a demand is not met, where the prosecution would be justified. And he cites Williams and Bailey and Kaufman, which my Lord Burrows referred to. They also explain a series of old salvage cases, which agreements were made by masters of ships in distress. And then this formulation stated in Chitty was recently endorsed and applied by Mr. Justice Warren in Times Travel. And he sets out the case. And just below letter D, the travel agent whose business depended critically on selling tickets for the airline signed a new agreement. The judge declined to find the airline had acted in bad faith in requiring the agents to give up their claims for past permission. But applying the test stated in Chitty, he held that the agents had been induced to enter into the new agreement by illegitimate pressure and were entitled to rescind it. And then he refers to the article in the Law Quarterly Review, written by my learned friends Jr., Professor Davis and William Day, where they justify the decision and refer to the fact, correctly we submit, that the threat made in effect to terminate the agency unless the claimants gave up accrued rights to commission, though lawful in itself, was inextricably linked to previous unlawful conduct, not paying commission due under the old agreements. The authors also argue, even then, treating lawful conduct as amounting to duress is questionable. There's a clear difference between lawful and unlawful behaviour. No good reason has yet been given why lawfully applied pressure, even if closely connected to unlawful pressure, can be illegitimate. And then Lord Justice Leggett says, this is a difficult area of the law, but for my part, I see no reason to doubt the correctness of the approach adopted in Times Travel. Whereas the distinction between lawful and unlawful behaviour may be critical in determining whether the defendant's conduct is actionable in tort, I see no reason why it should be decisive whether the defendant can retain money or other benefit demanded from a claimant in a situation of extreme vulnerability. For this purpose, it is appropriate to take into account the legitimacy of the demand and to judge the propriety of the defendant's conduct by reference not simply to what is lawful, but to basic minimum standards of acceptable behaviour. The complaint that this makes the law uncertain, I'd give two replies. First, the authorities have emphasised the standard of unconscionability as a high one, and only in cases where the demand made means used to reinforce it are completely indefensible, that the courts will intervene. Secondly, no apology is needed for intervening in such cases, as the enforcement of basic norms of commerce and of fair and honest dealing are an essential function of our system of commercial law. So
it strikes me, Mr. Shepherd, that the discussion here, the language, for example, opposite letter H in paragraph 187 of extreme vulnerability, and then going on to a standard of basic minimum standards of acceptable behaviour. it strikes me as very very reminiscent of a language used in equity, for example, in William and Bailey, where what seems to have been important in it, well, what was emphasised by the House of Lords was the vulnerability of the elderly father to pressure directed at his relationship with his son. And I'm wondering, are we I know we even uses the word unconscionable here. Are we really talking about the application of equitable doctrines of either unconscionable transactions or undue influence, rather than something that's truly analogous to the old doctrine of duress based on threats to the person or property?
Yes, my lord, our submission is that it would be wrong to consider that one is looking at the equitable doctrines in their full measure. One is looking rather at descriptive terms which will be familiar to judges, so as to describe behaviour that is so far out with the norm of commercial fair dealing as to be such that the law does not consider the pressure legitimate. My lord, just let me put some meat on the bones. What happened in this case was that completely out of the blue, there arrives step backwards. My clients make their claims for commission that is owed over several years, and so do 32 other agents. My clients are a small travel agent that is family owned and run. They rely almost entirely on their ability to sell tickets for PIA.
Yeah.
The result is that instead of seeking to resolve that claim in court, what happens is that the respondents serve a notice to terminate an existing contract, which they are entitled to do. But as I'll show you in a moment, the only reason for serving the notice was not that they wanted the agreement to terminate, but that they wanted to force the hand of the agent into giving up those past claims. That was the only justification for giving up well over £1 million worth of already accrued income. Now, if that is to be behaviour that is acceptable, well, so be it. But, my lord, that's what happened. £1 million worth of accrued commission, forced to give that up in circumstances where, if they don't, they'll be put out of business in a matter of weeks. So, my lord, whether one calls it unconscionable behaviour or not, it was behaviour that was completely indefensible. The only interest that the respondent had in serving the notice and forcing my clients into the position of having to sign the new agreement to give up those claims was so as to avoid the claims. There was no other commercial interest whatever. And indeed, Mr. Justice Warren finds that that is the reason for the claim, for the service of the notice. So however one looks at the matter, whether it's honest dealing or behaviour that is commercially indefensible, whatever that is, be qualified for the purposes of this case. And one must remember that the trial judge was in a position to make an assessment on the evidence. And here we have a Court of Appeal interfering in that assessment and coming to an opposite conclusion, something which courts ought to do with some hesitation. Let me turn.
The reason, Mr. Shepherd, why I was asking you about this was not to question your submissions about the merits, if you like, who has the moral high ground here. Although it might be said against you that Pakistan International Airline was in a position of monopoly supplier on whom the travel agent was dependent. And if they're abusing monopoly powers, that's not something which the common law would normally interfere with. And it's a matter of competition law. And if they had, for example, said, we're going to terminate your contract as we're entitled to, but we'll offer you another one if you pay us £1 million. You know, we're wanting a fee paid for this contract. It would amount to the same thing commercially. Just be a way of funding the payment of the commission. But the reason I'm pressing on it is really to think about what line, in terms of legal principle, should we be thinking about this as a development of the doctrine of duress that needs to be made to fit as a development of the principles of duress as they existed before Lord Justice Staines's dictum, or are we really talking about, is this better understood as the development of equitable doctrines of unconscionable behavior or undue influence? And it may be that that's a better way of looking at it, but if so, that ought to be the focus of our inquiry. And there's implications that go with it, obviously, to do with late sheets, clean hands, and so forth.
Yes, my lord. My lord, let me just answer that in this way, that there has always been a relationship between duress and equitable doctrines. But the equitable doctrines grew up in a different tradition. And the equitable doctrines tended to focus on vulnerability and exploitation. Common law doctrines were not concerned, or as they grew up, were not concerned with vulnerable victims. What they were concerned with was the fact that in a particular case, consent had been given in circumstances where there was a gun to the head, which can happen in all manner of circumstances. The reason that matters, my lord, is that the sort of doctrines that grew up around those in a position of vulnerability necessarily focus on the nature of the relationships. Whereas here, the nature of the relationship it isn't critical. What is critical is the nature of the consent. And here, contracts are founded on mutuality, whereas equitable doctrines don't share that characteristic. My lord, these are big questions, and perhaps I can give further thought to them and address them in reply. But there are a few submissions that I really need to make. My lord, as to the approach taken by the Court of Appeal, my lord, if you go to page 232 of the bundle, at paragraph 105, that is the core of the decision of the Court of Appeal, where my Lord Justice Richards, with whom the other Lord Justices agreed, says, my conclusion on the central legal issue is that the doctrine of lawful act duress does not extend to the use of lawful pressure to achieve a result which the person exercising pressure believes in good faith it is entitled. Just pausing there, my Lord comes to the conclusion that he doesn't come to the conclusion that lawful act duress is completely out with consideration. But what he focuses on is achieving a result which the person exercising the pressure believes in good faith it is entitled. But there's a sting in the tail, and that's this. And that this is so whether or not, objectively speaking, it has reasonable grounds for that belief. Lord, that we submit is an extraordinary outcome for a doctrine that is supposed to be focused on the consent of the party coerced. It's extraordinary because it's focusing not only entirely on the coercer and his beliefs, but adds as a rider that it is not an analysis to be conducted objectively, but it is specifically one where the person who's exercising the pressure it becomes the sole arbiter of the reasonableness of his belief. So the court is left out of the analysis, so is the party coerced. And he goes on to say, the common law and equity set tight limits on setting aside otherwise valid contract. Well, my Lord, take misrepresentation. There is no limit that says that the party who made the misrepresentation should be the sole arbiter of whether he made the misrepresentation or not, or whether other grounds for setting aside contract should focus entirely on the state of mind of the person whose conduct is in question. Goes on to say, common law set tight limits. In this way, undesirable uncertainty in a commercial context is reduced. Well, Lord, we ask rhetorically, how does it reduce uncertainty to focus solely on the potentially completely unreasonable state of mind of the coercing party? It goes on to say, I appreciate that in the context of the present case, which concerns the reasonableness of the grounds for resisting the claim, it can be said that a test of unreasonableness is not uncertain, because it can be tested according to conventional legal standards. Well, so it can. But that will not be the case in the much more common situation of a party using lawful commercial pressure to support a purely commercial demand. Well, the trouble is that using expressions like a purely commercial demand, is it a purely commercial demand that I expect my agent to give up the £1 million worth of accrued earnings because I no longer wish to pay him? Is that a normal commercial demand? And how does one set the parameters of the normality of commercial demand? It swaps one brand of uncertainty for another which is far worse. So I submit that, my lords, if a party applying the coercive pressure, hence the same party whose behaviour is under scrutiny, no matter how unattractive, no matter how unreasonable, itself appreciates in bad faith that it isn't entitled to the demand that the pressure is aimed at supporting, then and only then will, it seems, lawful acts will qualify. Well, my lord, in that event, we may as well not have a law of duress. Certainly we may not have a lawful act duress, because such a thing will be quite impossible in practice to prove. My lord, in the 6 minutes left, I just want to address good faith and bad faith in a little more detail. The problem with elevating good faith and bad faith into a necessary ingredients of duress are as follows, or include the following. 1. First, a doctrine that focuses simply on the belief, reasonable or otherwise, of an alleged duressor would be one that simply ignored the very real effects of the pressure upon the party who has no practical or reasonable alternative than submission to the demand. It places the emphasis on the wrong party, namely the duressor, and completely ignores the party who is forced to contract. The reason that is so objectionable is that it fails to focus on the rationale for the doctrine existing in the first place. 2, as has been observed, and rightly so, a club wielded in good faith feels the same to the duressee as one wielded in bad faith. And it is the duressee who is seeking to avoid the contract and who is the proper focus of the doctrine. 3, on the other side, we recognise that the law cannot have a doctrine that focuses just on the victim's subjective view of the pressure. An objective element is not only necessary, it is also desirable as a matter of policy. Fourthly, bona fides or otherwise of the pressure applying party may of course be a factor in assessing the legitimacy or otherwise of the pressure applied to support the particular demand. But that is all it can be. As Lord Justice Steyn recognised in CTN and Mr. Justice Dyson in DSND, a factor. Otherwise, the autonomy interests of victims of pressure are insufficiently taken into account. And autonomy is a key principle of the law of contract. 5, it must be in the nature of the demand rather than the jurecee's belief that justifies the law's intervention. An exploiter is no less an exploiter simply because they happened to subjectively believe that they are doing no wrong. As far as, and in this context, monopolists do not enjoy special privileges, and the fact that monopolies are controlled by statute does not mean that this court ought to give monopolists a special privilege and that monopolists can relabel their conduct as the exercise of monopoly power and thereby escape the attentions of the common law. 6, the law of compromise deals with the honest belief problem. There is one who experiences the pressure, who knows what's going on and submits to the demand voluntarily in order to shut down what is acknowledged to be a bona fide dispute or claim, even if they felt pressed to do so. The law of compromise deals with the honest belief problem. 7, that if that is not the reason for submission, then why should it be open to the victim to assert duress as the substantial reason for entry into the transaction? Why should it not be open to them? 8, if good bad faith is adjudged as the Court of Appeal would have it, without reference to the reasonableness of the underlying grounds held for the belief, then what, if any, yardstick is the court to apply? There is no yardstick. It simply becomes a matter of the defendant's stated belief. 9, we submit that making the duressor's belief, however unreasonable the touchstone of whether it acts in good or bad faith, is indefensible, because the court should be the arbiter, not the party whose conduct or misconduct is in question. 10, as APPG puts it, and we support, it would be undesirable for this court to leave undisturbed the proposition that no behaviour by a defendant, so long as it is on the right side of unlawfulness, can ever lead to a contract being set aside for duress, if the defendant subjectively believes itself to be entitled to demand of the claimant whatever it is that the contract commits it to. And finally, penultimately finally, whose goodwill or bad will is to be examined? When dealing with large corporations, who is it that is to be the subject of the inquiry? And who within an organisation will represent the goodwill or bad will of Megacorp? I was going to draw attention to some of Mr. Justice Warren's findings, but if I can just do that very briefly in 2 minutes. First of all, Mr. Justice Warren makes the following findings. He finds that the respondent never had a defence to the commission payable on the YQ claim prior to October 2010. Secondly, he finds that the respondent had discouraged the appellant from litigation and strung it along. See paragraph 53, page 253. Thirdly, they had told the appellant that historic claims would be paid. See paragraph 224, subparagraph 2, page 289. Next, they had refused to allow the appellant to take legal advice when the contract was presented to them. See paragraph 14, page 210. Next, they'd served notices on the claimant on the appellant in circumstances where they knew that alternative business could not be found in the time frame. See paragraph 121, subparagraph 4, page 267. Next, they had no real intention that the appellant should cease to be their agent. See paragraph 260, sub 2, page 297. Next, the ticket allocation was reduced for the sole purpose of putting as much pressure as possible on the appellant in order to enter into the contract. See paragraph 179, page 279. The only purpose of giving notice was to require the appellant to give up their claims. There was no other purpose. Yes. I think I've covered all my points and I've outstayed my welcome. Well, Lords, those are my submissions. I'm sorry they were so hurried.
Thank you very much, Mr. Shepherd. So I think we turn next to Mr. Hankey on behalf of the intervener Ukraine.
My Lords, I'm grateful. My Lords, can I just, we had a blank screen for a moment. Can I just check you can hear me properly?
Yes, I can see and hear you.
Excellent. My Lords, I'm going to take Ukraine's written case as read, and in the limited time available for oral submissions, I wanted to focus on a few points made principally in its written case by Lord Abenture, which, as most of your Lordships are aware, is expressly acting upon the instructions and for the benefit of the Russian Federation. So when I refer to Russia, that can be taken as, I hope, convenient shorthand for the second intervener. The first point I wish to cover was the status of lawful act duress in English law. And it's remarkable in our submission that Russia has spilled a lot of ink explaining to your Lordships why the Supreme Court should not extend the common law to encompass lawful act duress, and why they go on to say, citing El Ghazouli, that the matter should be left to Parliament. The problem with this analysis is that the concept of lawful act duress is already an accepted part of the English common law. The English courts and the Privy Council have well understood the distinction between a requirement of unlawfulness and a requirement of illegitimacy, and have chosen their words carefully to embrace illegitimacy as the relevant yardstick for economic duress. It is also the accepted view of the law in the main textbooks, which Ukraine cites in its written case at paragraph 11, and I won't repeat here. My learned friend Mr. Shepherd took your Lordships to the Crown and the Attorney General for England and Wales, the SAS case. I'm not going to turn that up again, but remembering the passage that Mr. Shepherd took you to, it's notable that the Privy Council does not suggest that all threats of unlawful action even would be illegitimate. That is ultimately a jury question, depending on the nature of the demand. For example, a builder seeking variations to a contract, as he has, say, underestimated the cost, and cannot afford to perform the original contract would not necessarily be necessarily be exercising illegitimate pressure. That is a jury question, depending on the nature of the threat or the statement of facts as to his inability to perform the contract, and the nature of the demand attached to that threat or statement of facts. So it's always a question of fact, and it's ultimately a jury question for the judge as to whether the threat is illegitimate or not. And that isn't decided by a simple analysis of whether the threat is unlawful or lawful. It's more complicated than that. Illegitimacy is a more nuanced question. And ultimately, I'll come on to this in a moment, but put simply, we say there isn't any particular need to overcomplicate this area of the law by trying to insert the criminal law of blackmail or any of its ingredients into the law. It's a simple test, as enunciated by the House of Lords in Universe tank ships and other cases. Did the illegitimate pressure induce apparent consent? As to the meaning of illegitimate pressure, as I say, that's a jury question and couldn't be better put than by Professor Burke's as cited in CTN, which is a question of moral or social unacceptability. On the significance of the use of illegitimacy, my learned friend Mr. Shepherd took you to Lord Borough's restatement of the English law of contract at MS 6991, and I'm not going to repeat that. But what I do say is, against the background of looking at the dicta in Universe tank ships, looking at the Attorney General for England and Wales case, the SAS case, we say the Court of Appeal in the present case was wrong not to accept Mr. Shepherd's submission as to the significance of the use of the concept of illegitimacy rather than unlawfulness by the courts, repeatedly so. And that's the conclusion in paragraph 53 in Lord Justice David Richards' judgment.
Can I ask, Mr. Fenke, if it's a jury question, then do you accept it follows that different judges might quite properly arrive at different conclusions?
Yes, I think once you say something as a jury question, there is that possibility on the same set of facts. But that's something which the law accepts as a risk of setting a jury question.
Yes. Okay. Thank you.
And the Progress bulk carriers case, we say, has to effectively be reanalyzed by both Pakistan in its written case at paragraph 43 and by Russia in its written case at paragraph 23 as a case which was somehow connected, inextricably connected, they say, to an earlier breach of contract, and therefore was a case of unlawful act duress. But in our submission, that was not the basis on which Mr. Justice Cook decided the case. And if I could just take this, Mr. Shepherd was strapped for time, and if I could just take this a little bit longer and perhaps turn up a few more passages in Progress, which is at MS 2021. So Mr. Shepherd took you to some earlier passages. If I could pick it up at 2021, one can see at paragraph 21, and it's very important to understand in looking at the Progress case, the actual submissions that Mr. Justice Cook rejected, and you get those from paragraphs 21 and 22 on page 2021. You see at 21, the owner's primary submission was that economic duress only operated the victim was subjected to pressure by unlawful action on the part of the perpetrator. And it said that all the reported cases of economic duress, it was said, involved a minimum required of unlawfulness, etc., etc. And then at the end, threats to carry out acts which are themselves lawful can be unlawful where they constitute blackmail, but there is still the element of unlawfulness in the pressure. So that's the first submission by the owners. The second submission, their alternative submission, was if the conduct which was lawful could amount to the requisite illegitimate pressure, the bar had to be set very high and the pressure would only be branded as illegitimate where it provoked such a sense of moral outrage and appeared so unconscionable, or so manifestly beyond the norms of ordinary commercial practice, that it could be considered on a par with conduct the law does expressly recognise as illegal or criminal. So those are the two submissions which Mr. Justice Cook rejected. And just going through this judgment, at paragraph 25, you see the references to Universe tank ships. Mr. Justice Cook referred to Lord Diplock's speech in Universe tank ships, but he could easily also have referred to Lord Scarman for the same proposition, which is at 26. Mr. Justice Cook says, as far back, therefore, as 1983, the highest court in the land recognised that economic duress could arise where what was being done was not in itself an actionable wrong. And then 27, there's an extensive citation beginning there of the CTN cash and carry case. If we go on to 2024, paragraph 30, Mr. Justice Cook summarises that analysis by saying this is Court of Appeal authority for the proposition that the exertion of pressure by lawful means does not prevent the operation of the doctrine of economic duress. Whilst the particular examples in earlier cases to which reference is made in the passage quoted above do not take the matter much further, Lord Justice Steyn refers to the critical inquiry as being not whether the conduct is lawful, but whether it is morally or socially unacceptable. He said in terms that that was the inquiry in which the court was engaged, although the court should not set its sights too high, and it might be a relatively rare case in which lawful act duress could be established, particularly in a commercial context. Mr. Shepherd took you to the proposition in CTN that one should never say never in this context. And then Mr. Shepherd has taken you to paragraphs 31 and 32. 33, there are references to the DSND and the Adamopol case. And then at paragraph 34, could I just ask this court to note that Mr. Justice Cook analyses the Borelli and Ting case in 34 in identical terms to the way in which Lord Justice Leggett analysed it in the El Nayan case. And I'll, rather than dwelling on this paragraph, I'll take you very briefly to the summary in El Nayan in a moment. And then paragraph 35, Mr. Justice Cook notes the unanimity, virtual unanimity of the major textbooks on the topic. I'm not going to spend time on that. And then at paragraph 36, see that Mr. Justice Cook says the question of law poses whether the owner's conduct as found in the award and the reasons amounted to illegitimate pressure required to establish economic duress in law. As indicated above, it was accepted that the question could be reframed by asking whether or not the arbitrators applied the wrong test in law in analysing facts. Then this critical passage, it is in my judgment clear from the authorities that illegitimate pressure can be constituted by conduct which is not in itself unlawful, although it will be an unusual case where that is so, particularly in the commercial context. And then the last sentence in that paragraph is the only passage that the trustee quotes from in its written case at paragraph 21. It's also clear that a past unlawful act, as well as the threat of future unlawful conduct, can, in appropriate circumstances, amount to illegitimate pressure. But his primary conclusion, you see at the beginning in the preceding sentence, and then one can see paragraph 42 and 43. At page 2027, Mr. Justice Cook first of all rejects the submission in paragraph, so he set out in paragraph 21, at paragraph 42. Owner's primary position in law is unsustainable, since for the reasons I have held, illegitimate pressure can involve the doing of acts which are not unlawful in themselves, albeit unusually in commercial cases. And then the next point he makes is a what is more type point. His basic conclusion is at the beginning of 42 in rejecting the owner's submission. And in 43, the owner's alternative test, i.e. The requirement of conduct which is tantamount to unlawfulness, he says the owner's alternative test for legitimate pressure can fare no better than the test advanced in their primary case. Such a test is not supported by any authority, and once accepted that there is scope for the doctrine to operate where the threatened act is lawful, each case will be fact sensitive. And then he says, just above B, self-evidently, the more serious the impropriety and the greater the moral obloquy which attaches to the conduct, the more likely the pressure is to be seen as illegitimate. So in our submission, looking at Mr. Justice Cook's conclusions there, his primary reason for rejecting the owner's application was that lawful acts can constitute duress. And we say, in any event, trying to re-explain progress bulk carriers based on some connection to a past breach of contract is unsatisfactory. It is not in itself a clear test, as Mr. Jones and Mr. Jones, two Mr. Joneses would advocate is paramount here. And such an approach fails to recognise that duress can exist without any past contractual relationship. So just briefly to address the decision of the Privy Council in Borelli, if I may, in the interest of time, the decision is relevantly summarised by Lord Justice Leggett in Al Nyan. And if we could go for these purposes to page 700. And in page 700, it's towards the end of paragraph 182, which begins on the previous page, but we can pick it up just below letter D on page 700. In Borelli and Ting, the Privy Council set aside a settlement agreement as having been obtained through duress, consisting of unconscionable conduct. Under the agreement, the liquidators of a company had agreed not to sue the defendant, a shareholder accused of misappropriating assets of the company, in return for his agreement to withdraw his opposition to the scheme of arrangement which was needed to raise funds for the liquidation. There was a background of unlawful conduct, as the defendant had previously used forgery and provided false evidence in opposing the scheme, but neither the demands to which the liquidators agreed to drop claims against him, nor the accompanying threat to vote against the scheme was unlawful. So we say Borelli, like Progress, is a significant case in the logical development of the law. Can I then turn to my second topic, which is the criminal law? There are academic commentaries on the relationship between criminal blackmail and civil duress, which may be of assistance to the court in this context. And if I can start, if I may, with Lord Burroughs' Law of Restitution at 6998. And on the right hand, if you can read this, on the right hand page 257 internally, in the middle of the page, Professor Burroughs, as he then was, says a layman may describe duress as blackmail, but blackmail is a crime and it can be misleading to reason from one to the other, as the ambit of duress in civil law should be and is wider than criminal blackmail. Having said that, it is interesting that the actus reus of blackmail can clearly include threats to carry out acts that are not crimes or civil wrongs, for example, reporting a crime to the police or disclosing adulterous relationship to the press. In the light of this, it is not at all surprising that, as we shall see, the ambit of illegitimate threats in civil duress is not confined to threats to carry out unlawful acts. And then, if we can then look at Professor Smith at 6853. This is the article which Mr. Shepherd referred to earlier, originally published in the Cambridge Law Journal. And if we could go to 6853, about four lines down. Sorry, let's start at 3 lines down. Professor Smith says that an observation concerning blackmail is, although the distinction between unlawful and wrongful is not supported by blackmail cases, it has some significance for deciding blackmail cases. Because of the distinction, what counts as blackmail for the purpose of establishing duress may legitimately be broader than what counts as blackmail for the purposes of criminal law. The legal response is weaker, nullity as opposed to punishment, so the legal test can be weaker. So, my lords, against that background, it's interesting that no other party has commented on the fact that a threat of lawful action, for example, to commit suicide, which ceased being a crime in England in 1961, can give rise to a defence of duress in criminal law to avoid criminal sanction. And we give the references in our written case, paragraph 13, page 169. In the circumstances, we submit that given the absence of a bright line based on the legality of the threatened action, as opposed to its seriousness in criminal law, it would be odd to draw such a bright line for the purposes of the law of contract. And just giving your lordships the reference to criminal duress, we cite the decision of the Court of Criminal Appeal in the Crown and Martin in our written case at paragraph 13, footnote 13, and the summary of the facts and the three ingredients of duress in criminal law are at pages 2047 to 2048. And just for your lordship's notes, that decision has been followed by the Court of Appeal in DPP and Rogers, which also mentions its approval by the Court of Appeal in an unreported decision, and the reference is 3427. Then, trying to go at some pace, third topic I wanted to deal with as briefly as possible was other jurisdictions. Russia, in its written case, says that there is no common law jurisdiction in which lawful act duress has been applied. That's the section above paragraph 11 of Russia's written case, and we say that is wrong. It's notable that although Russia gives a list of jurisdictions in its written case at paragraph 13, Hong Kong, for instance, is not one of the jurisdictions mentioned by Russia, despite the Privy Council's decision in Borelli, which we've just looked at. Singapore is also missing from Russia's list. We address that in Ukraine's written case at paragraphs 19 to 21. New Zealand is addressed in Ukraine's written case at paragraphs 22 to 24, and we say the leading authority is obviously the Crown and the Attorney General for England and Wales, which Mr. Shepherd has taken you to and I have referred to. Canada is addressed in Ukraine's written case at paragraphs 25 to 29. I won't say any more about that now. Australia, we address the mixed picture emerging from the various Australian jurisdictions in our written case at paragraphs 30 to 31. Russia, by contrast, focuses only on New South Wales, where the case law is more favourable to its argument. But we would ask you to look at the position in Australia as a whole, which we develop in paragraphs 30 to 31 of our written case. Now, the United States, the law of duress is a matter of state law, and hence a matter on which there is extensive authority which is not uniform. Ukraine sought to adopt a proportionate approach by focusing principally on material set out in the restatements of unjust enrichment and contract, respectively, with some limited examples taken from the restatements. And that's at Ukraine's written case at paragraph 16 to 18. Russia has since added no less than 25 US cases, none of which were referred to in its written case, into the authorities' bundles before the court. But with great respect, they don't take matters much further. For example, Russia has added cases from Louisiana, which operates on a civil law system and where the relevant law of duress is part of a civil code, is therefore unlikely to illuminate the common law. Now, just going back to the restatements, it's true that some of the restatements have been controversial as to whether they state the law as it is. But the fact that duress can extend beyond unlawful acts is clear and well supported by references to the case law in the restatements. In the interest of time, I propose just to give some references to the third restatement of restitution and unjust enrichment, which is at page 7199. And I'm going to go at some pace, but if I may just quickly summarize the key points. There is page 7202, letter G, which refers to impermissible coercion, which refers to the need for a social judgment on the legitimacy of the pressure applied. And that language is reminiscent of Lord Justice Stayne citing Professor Burke's in the CTN case. It is also reminiscent of Lord Burroughs' reference to threats which are alien to society, in English private law, paragraph 18.67 at page 6987. That's in English private law, paragraph 18.67. And then at 7203, there are references to lawful coercion becoming impermissible when supporting bad faith demands. At page 7204, there is recognition of the possibility of duress even where lawful means are used in good faith. At 7205, this refers to threats to exercise legal rights, which may constitute duress if used for collateral purposes. And I'd ask the court to look in particular at illustrations 19, 21 and 24 at pages 7206 to 7207. And the supporting material to this part of the restatement is set out at pages 7210 to 7213. Now, just a few words about certainty, if I may. Both Pakistan and Russia emphasize the importance of certainty in the law of contract. Times Travel has already made the points that certainty is not the only desirable goal, and that certainty does not always trump other desirable goals in other areas of the law of contract. For example, as Mr. Shepherd adverted to, the multi-factor test for illegality. Now, Ukraine would simply add this, that the citation of disparate authorities from different aspects of the law of contract, for example, rectification, is unlikely to assist in answering the question presently before the court. As Lord Justice Leggett said in Al Nayan, the threshold for lawful act duress is set high. The problem is therefore a narrow one, and certainly not likely to cause a floodgates problem, as Pakistan suggests in its written case. And abolishing lawful act duress would not improve certainty, given that no one suggests that progress bulk carriers or Borelli should be decided differently. But explaining them away by reference to some amorphous connection to prior unlawful conduct does not provide any clearer test. There are some suggestions by Russia that some or all of the work done by economic duress could be done by undue influence, but that would just shift the debate to the boundaries of that doctrine, but not make the task of the parties or their advisors or the court any easier. And I'll come back in a moment, if I may, to my Lord Reed's question about unconscionability and equity in a moment. And we would say that Russia's own submissions tacitly acknowledge that bad faith is not such a difficult or uncertain concept to apply, which is its fallback position in its written case at paragraph 83. Just a few points about Walford and Miles. There's a suggestion made by Russia in its written case at paragraphs 43 to 45 that if bad faith lawful act duress existed, then it would be inconsistent with the decision of the House of Lords in Walford and Miles. We say that is wrong. Walford and Miles rejected the possibility of an agreement to negotiate or an agreement to agree because it lacked certainty. and an agreement to negotiate in good faith was no more certain because the party was entitled to withdraw from negotiations for any reason. That's at page 2334. The problem is not that good faith is somehow always too uncertain as a legal test, as may be hinted at in Pakistan's written case in footnote 36. For example, in addition to Russia's acceptance that many important commercial contracts include duties to act in good faith, the change of position defence depends on the party changing their position in good faith. But we do submit that catching bad faith lawful acts, if that is the way the law progresses, is not in any way inconsistent with Walford and Miles. If parties choose to negotiate, then they must not act by seeking to apply illegitimate pressure, including in bad faith. If they choose to apply such pressure in bad faith, that is not in itself a breach of any duty, consistently with Walford and Miles. It is only relevant, it only becomes relevant, if that illegitimate pressure procures a contract which is liable to be set aside. And then finally, on the relationship between equitable concepts such as undue influence and duress, which my Lord Reid asked about, can I just refer you briefly, if I may, to page 7011 from Professor Burrows' Law of Restitution, as he then was, and one sees at page 7011 in the right-hand column, under the heading Duress and Undue Influence, I hope this is of assistance, where Lord Burrows says there is a close link between duress and undue influence. Indeed, until the recent expansion of duress, undue influence is regarded as embracing threats or pressure that fell outside the then narrow doctrine of duress, as recognised by many commentators and some judges. Since the acceptance of economic duress, it is rational, in order to avoid an overlap between undue influence and duress, to treat cases of illegitimate threats pressure as examples solely of duress. They have therefore been excluded from this chapter, etc. So that may assist. And also, just by way of interest, there is an article, quite an old article now, by Professor Burrows, as he then was, which I'm about to run out of time, but I just mentioned to give you the reference, which is at is at page 6585, which is an article from the Oxford Journal of Legal Studies from 2002, called "We Do This at Common Law, but That in Equity," which Lord Burrows will recall. But it's an article arguing that lawyers are not doing enough to eradicate differences in terminology used and substantive inconsistency between common law and equity, etc. But I mentioned that in passing because it has some points which are of interest to the question that my Lord Reid posed.
Yes, it's not simply a question of language, but for example, whether there's a limitation period for bringing proceedings. It's quite, it could be quite important whether we treat this as an equitable doctrine or a common law doctrine.
In my submission, it is neater and easier, given the development in the law of duress, particularly since CTN onwards, from universe tankships onwards, but particularly the marker in the road marked by CTN. It is neater and more logical to treat duress as a self-contained doctrine, although undoubtedly, as in many doctrines, it has been influenced by equitable doctrines along the way. My Lords, unless I can assist you further, I think I've run out of time.
Thank you very much, Mr. Sankey.
I'm obliged.
And I think finally for this afternoon, we turn to another intervener, the All-Party Parliamentary Group on Fair Business Banking. And Mr. Rowe, I think you're presenting submissions on their behalf.
My Lord, I am, thank you. My Lord, we've very properly been limited, I think, to 20 minutes of submission, so I shall use that time, if I may, to stick to two short propositions. The first proposition is this: it is that this court should reject the proposal to rule out the possible existence of lawful act duress as being misplaced. The appellant and Ukraine, in their submissions that your lordships have heard during the course of today, have of course already dealt with a number of cases that show the doctrine of lawful act duress either being applied to decide whether or not to uphold or to invalidate contracts, or more frequently adverted to as a possibility. And in those cases, both the ones where they were applied and the ones where the possibility was adverted to, we are concerned with decisions and observations by, one can't help but notice some of the household names of British jurisprudence over the last few years. And it's striking that with only a few exceptions, I think nearly all of the people, most of whom were judges, not all of whom were judges, whose words on this subject have been quoted, either were or later became members of the present court or its predecessor committee. So in our submission, my lords, this court would need a fairly strong basis for ruling that those decisions and those observations were all wrong, or in the case of the decisions, and I have in mind in particular Progress and Borelli, that for ruling that in fact in those cases what was really happening was that, albeit they didn't realize they were doing it, the judges were deciding the case on the basis of unlawful act duress, even though, as I say, they didn't think that they were doing it themselves. And your lordships would have to say that about Progress Bulk and about, in my submission, about Borelli, which of course was a decision of the Judicial Committee on appeal. I think it was said earlier from Hong Kong. It was concerned Hong Kong, but it was on appeal from the Court of Appeal of Bermuda. But the point is the same. So it would be a strong thing to do, in my respectful submission. And we respectfully submit there is no basis for such a ruling. In principle, we submit the idea that that no combination of, one, what the claimant agreed to do in the contract that we're concerned with, and two, what the pressure was that the defendant placed on the claimant to agree to the contract is capable of vitiating the claimant's consent, is a deeply counterintuitive idea. Instinctively, one feels that there ought to be cases where, lawful or not, the combination of those matters, what it was the claimant was being asked to sign up to, and what was done to the claimant or threatened to be done to the claimant, more accurately, to get the claimant to do it. One feels it should be sufficient in some cases for that to vitiate consent. But the fact that it's perhaps sometimes difficult to articulate the precise circumstances in which the court will say that the claimant need not be held to his, her, or its bargain doesn't mean in our submission that such circumstances cannot be seen when they happen, or that judges cannot be trusted to use their good sense not to intervene, except rarely and on solid grounds. And that's an approach, we say, which is respectfully, that has served the law perfectly well in other areas. As we mentioned in our printed case, a standout example, one might say, is in public law, where, of course, although the courts have developed a sophisticated body of law about ultra vires and failure to take into account relevant considerations and so on and so forth, there remains a residual category of decisions where the courts reserve to themselves a jurisdiction to say this decision was so unreasonable that no reasonable decision maker could have made it, and they quash it on that basis. And it's not the case that position in public law has let the floodgates open to vast numbers of unmeritorious claims that can't be dealt with. I appreciate, of course, there are different procedural provisions there, but it might well be thought that in the present context, and I'm sure my clients would say in the present context of civil litigation, there are plenty of practical obstacles to the bringing of unmeritorious claims, not least the cost of doing so. So in our respectful submission, there's no pressing need to, as it were, abolish, if it exists, the doctrine of lawful act duress. Indeed, we would say not only is there no good reason to accede to the invitation to insist that nothing less than unlawful conduct will do, there is good reason not to. The particular concern of the all-party parliamentary group is driven centrally by its experience of its own members, the members of the parliamentary group, who have themselves experience of hearing directly from those who run small and medium-sized businesses about their interactions with financial institutions. And the group were moved to seek to intervene in this appeal, and indeed thank the court very much for being given the chance to do so, in part because of their concern that the hard line which is proposed by the respondent and by the Law Debenture Trust intervening would remove a possible source of legal protection from a group who are already, in many respects, in a vulnerable position. And we deal with this in more detail in our printed case, and I won't rehearse all of that. But in our respectful submission, for all of those reasons, and echoing obviously to a certain extent what has already been said, the first proposition that we advance is made out. The notion that one should rule out altogether the existence of lawful act duress is, we respectfully submit, misplaced. The second proposition is this, and it concerns good faith. We respectfully submit that whether the defendant acted in good faith, understood objectively, and that's important, of course, it is, we say, a useful tool to determine whether a given case is a case of duress or not. And this addresses partly the complaint, which I'm sure your lordships will be pressed with tomorrow from the respondent and from Lord Devonshire Trust, that I think by analogy they refer, for example, to Lord Sumption's observations in Patel and Mirza, that too much depends, if you leave this doctrine on the books, on the visceral reaction of the judge. And one might say, I suppose, that is a reasonable criticism of the appellant's position up to a point. It's the uncertainty point. And of course, it's perfectly true that duress as a doctrine is in tension with the finality of contractual bargains. And that need for finality is obviously very important, and it's just as important to those on whose behalf the all-party parliamentary group brings this intervention, because they themselves, of course, are particularly concerned in their daily lives and business lives with the sanctity of contract. They don't any more than anybody else want there to be a completely freewheeling doctrine that means that any bargain is unsafe and liable to be set aside at the whim of a judge. But the consequence of that is that there is a necessity for a search for, we submit, for tools which the court might usefully use to lend some degree of predictability to the exercise of considering a claim in duress. And we submit that good faith, properly so understood, might be a useful addition to the toolbox, at the very least. That the Court of Appeal's reliance in the present case was on a purely subjective notion of good faith. Of course, the airline thought, reasonably or not, so it was said that they were entitled to be exonerated from the travel agent's claims, and so the claim wasn't the claim of duress wasn't made out. We submit that isn't a useful tool in the toolbox, essentially for the reasons that are given by the appellant. Indeed, we would go further and say in the banking context, which is the particular concern of the all-party parliamentary group, it's positively dangerous. And my lord, I won't go to it now, but in our written case, if your lordships have it at page 159, we set out what a Court of Appeal comprising Lord Thomas, Sir Brian Leveson, and Lady Justice Gloucester said in the Hayes case about the way in which, in the experience of every member of that court, there were occasions where, in particular markets, collective standards were adopted. In that case, they were talking about honesty, but one could apply it, I would have thought, to all aspects of good faith, which, as I'll come on to say, incorporates more than honesty. They say in that case that in their experience, all members of the court have experience of particular markets where there is a collective failure to keep up with ordinary standards of honest and reasonable people. And that's a powerful reason in our submission why it's dangerous to hinge everything in this area of the law on simply whether the defendant subjectively believes that his or her conduct is acceptable. So in our respectful submission, that won't do. But what we do say is that there is a tool which is relatively well developed and might be useful, which is good faith properly understood, because we say that the observations that various judges have made in earlier cases about the relevance of good faith are well placed. And my lord, if again I won't, given the time constraints, start ploughing through the cases, but we summarise them at page 152 in the bundle in our case. I think these are all cases to which the court's already been referred, but the Peter Kramer case, the CTN cash and carry case, and the DSND subsea case are all instances where the courts have said that in considering whether or not the conduct under examination in all the circumstances constitutes duress, it is helpful to consider whether the defendant acted in good faith. And as I say, my Lord, we respectfully submit that's quite right. But it's important when considering that to bear in mind, we submit what we say properly so understood good faith really means. I appreciate good faith is perhaps a slightly protean term, and one can use it as a shorthand for not actively, subjectively dishonest, but properly understood in our submission, but more aptly used in this context. It doesn't mean that. It means two things. One, did the defendant act honestly? Which, as we know, and of course we're reminded by this court recently in Ivy and Genting, means, based of course on what subjectively the defendant thinks the facts are, was the defendant honest by the standards of ordinary decent people? But also, it means more than that. It means, did the defendant act in a way in which reasonable and honest people would regard as commercially acceptable or unacceptable? And again, given the time constraints, I won't go into all of the cases that show that, but we've set it all out in our printed case, my Lord. It's on page 155, where we set out a number of cases where, in a variety of different contexts, both statutory contexts where the Parliament has said that such and such a matter should be judged by reference to good faith, and as well and contractual cases where the courts have looked at or implied a term of good faith. In all of those contexts, it's quite clear that when one asks the question, did the defendant act in good faith, one is asking a question along the lines I just indicated. It's a matter of honesty judged objectively on the basis of the facts as the defendant believed them to be. And it's a question of objectively whether reasonable and honest people would regard what was done as commercially unacceptable, or to quote the then Mr. Justice Leggett in the Yam Seng case, improper, unconscionable, other terms that his lordship used there. And I appreciate, of course, using the wording unconscionable is liable to prompt the question that's already been prompted in the present case. I think for our part, we'd probably endorse Mr. Thankey's answer to that. But my Lord, that in our submission does provide some degree of reassurance if that tool of good faith is adopted, used in that sense. It does provide, I would submit, some degree of reassurance that what is contemplated here, if this court goes down the road of saying yes, there really is a doctrine of lawful duress, is not a throwing open of the floodgates, is not merely an appeal to what might pejoratively be called a jury question, but actually is an invitation to courts to adopt a relatively structured and principled approach. It might, of course, I can accept be said against us, and I expect it will be said against this point in general, that in a way this is still open to the charge that it's conclusory language, that it's, again, imprecise, that it leaves the law uncertain. You might say, how does asking whether the defendant acted honestly by the standards of ordinary decent people and in a way which reasonable and honest people would regard as commercially acceptable, how does that differ from asking whether the defendant acted illegitimately? Well, that's a fair criticism up to a point. In a broad sense, it doesn't. But in my submission, focusing on looking at the matter in that structured way, by analogy with good faith or by reference to good faith, it does help the court to adopt perhaps a more focused and structured analysis. Lord Steyn, whose observations in CTN as Lord Justice Steyn we've looked at, was fond, I seem to recall, of saying in various contexts that what was needed was an intense focus on the facts. It's a phrase that crops up quite a lot in his judgments. And in my submission, the approach that we advocate provides at least something of a structure or a lens, if one wants to take the analogy further, when considering the intense focus on the facts. It also shows, my Lord, this, that if this court takes the view that it should say loudly and clearly, yes, lawful act duress does exist, and the question is ultimately, as the Judicial Committee said in Borelli, one of whether the defendant's conduct is illegitimate or not, it's not sending the trial judges out into entirely uncharted territory. It's not leaving them with an completely unstructured jury question to address in whatever way appeals to their visceral sense of justice. Because although of course it's a relative novelty in English law, though other Commonwealth countries are perhaps more advanced in down this path than England is. The notion that there are contracts which import duties of good faith is a relatively well-established one now. Many contracts, of course, expressly do, and the courts do try sometimes to give effect to that. So there's already a body of thinking about how to deal with those sort of questions, which in our submission is potentially helpful. And it's no answer in our respectful submission to say, oh well, in purely commercial cases there is no pre-existing duty of good faith as between the parties. It may be in many of the cases, particularly the ones that my client is concerned with, it may be that actually there is at least the basis for arguing that there is a pre-existing relationship. You consider the situation of a business which has been banking with the same bank for many, many years. There are often personal relationships that have developed, and they are then in the process of renegotiating the whole situation. There is perhaps scope for saying this is one of those contracts which might probably be described as a relational contract, where duties of good faith may be implied. But quite apart from that, in our respectful submission, one doesn't need to have a pre-existing duty to act in good faith to make it relevant to ask whether the defendant has acted in good faith when considering the allegation that a contract has been entered into under duress. Because if one's considering the duress question, one's already got a situation where there has been pressure applied of one sort or another to get the claimant to do something which the claimant didn't want to do. And it's perfectly open in our submission in those circumstances, even absent a pre-existing duty to exercise good faith, to ask, did the defendant act in good faith, provided that one doesn't do it in the very limited way in which the Court of Appeal did in the present case, which essentially is simply to say, did the defendant subjectively believe that it was entitled to make the demand that it chose to back up with the threat which is said to constitute duress. My Lord, finally and briefly, because I'm conscious of the time, can I just invite the Court to look briefly at one case, which is the Morley case. And this is to be found in the bundle at 1783, I think, or at least picking it up at page 1783. And this is of interest to the All-Party Parliamentary Group because it is a case in the banking sector. And it was a case, amongst other things, about a threat that had been made by the bank when trying to renegotiate the relationship with a customer, that unless he went along with what was being proposed, the bank would appoint receivers to sell his property portfolio on a so-called pre-pack basis. In other words, as your lordships I'm sure know, telescoping the normal process of insolvency practitioners marketing and looking to sell the property into a fait accompli. And what we can see is that the way in which the judge was obliged to deal with that question by the court decision of the Court of Appeal in the present case was in a rather narrow and formalistic way. If we look at page 220, paragraph 223 rather, on page 1783, we can see that the threat described, the judge distinguishes between three different forms the threat might have taken, and in the end it was form 2 that was found on the facts. The bank would appoint receivers on the Monday to sell the portfolio on a pre-pack basis to West Register, which was essentially, in all but legal form, the bank. Following it through, 227, I'm taking this quickly because I'm conscious that I don't want to overstay my welcome. 227, Mr. Smith, who was the person who made the threat, believed he was acting lawfully, and so it was said it couldn't be duress unless it had been done in bad faith. There's a finding, again I'm skipping through it in view of the time, but there is a finding that it wasn't done in bad faith, in the sense that Mr. Smith believed that what he was doing was lawful. So the court then has to turn to consider the question whether or not this was a lawful act or not, and you get that, or you get the consideration of that from. Let me pick it up at page paragraph 257. If a conventional analysis is applied, therefore, it's very likely that what Mr. Smith was threatening to do, the bank would be to carry out an unlawful and defective performance of the bank's duties as mortgagee, and the court explains why that is. But then, because of the test into which the court has been pushed by the decision in Times Travel, the High Court here has to go on to consider in detail whether that's right. 258, we see it's not the end of the matter. Is that conventional analysis appropriate? And there are various reasons for suggesting why it might, or two reasons for saying why it might not be. The 259, the West Register might have redeemed the situation by undertaking to sell the properties onward on the open market. And 260, the claimant might have been found to lack any standing to challenge the receivership and pre-pack on the ground that any sale at an undervalue would not prejudice or otherwise affect him, because the negative equity position was such that he would gain nothing even if the properties were sold on the open market. And the reason for that is because of a peculiarity in this particular case, that the nature of the loan was such that he wasn't personally liable to repay it. So his interest, it might be said, was only in fact if the properties were sold for more than the value of the amount of the outstanding debt. Anyway, this leads the judge into an extensive consideration of whether that can be whether in those circumstances there was unlawfulness or not. And the conclusion that we get to at 267 is, in those circumstances, I cannot be satisfied that what Mr. Smith was threatening to do, was to do an unlawful act. He was threatening to do an act which might or might not turn out to be unlawful. It could be said that Mr. Smith's threat flirted with illegality, but did not inexorably commit to it. To be unlawful, the act would have to be unlawful vis-a-vis the claimant and not just in the abstract. The threat made was not to do an act that was unequivocally unlawful. I have therefore come to the conclusion that Mr. Smith stayed just the right side of the line. The case is close to the borderline, but I have concluded that I should categorise Mr. Smith's threat as part of what Mr. Justice Dyson in the Subsea case called the rough and tumble of the pressures of normal commercial bargaining. So that element of the claim to escape the contract on the ground of duress fails. It's not, of course, any part of my task or the parliamentary group's task to express a view about what the right outcome to that case was, or to invite this court to say anything on that subject, not least because, as I understand it, that task will fall to the Court of Appeal in the new year. But what is interesting in our respectful submission is that the way in which the learned judge in the Morley case had to go about matters illustrates some of the dangers we would submit, the difficulties of a purely rule-based approach that looks at simply whether this was lawful or unlawful, rather than stepping back and asking whether in all the circumstances this was an illegitimate threat. And our respectful submission is that, as a matter of generality, it's considerably more liable to do justice in the individual case if the doctrine is both preserved, as per my first proposition, and secondly, refined, as per my second proposition, by reference to the factors that courts look at when they're considering questions of good faith, objectively speaking. My Lord, I think that probably reaches my 20 minutes.
Thank you very much indeed, Mr. Rowe. Well, it's almost 4 o'clock now. We'll adjourn for the day and sit again at 10:30 tomorrow, when I think we will be hearing from Mr. Jones on behalf of the respondent. Very well. For the moment, we'll adjourn.